Welcome to The Legal Truth, the podcast created to provide you general legal information about South Carolina law, lawyers, and the legal process. We will answer many of the questions I've been asked during the past 35 years about South Carolina personal injury claims and workers' compensation claims. My name is Dirk Derrick. I'm the founder of the Derrick Law Firm, and I'm your host.
Please see required ethics disclaimers in show notes.
We're here today with The Legal Truth, and my co-host today and going forward will be Pearl Carey. Pearl is a recent graduate from The Ohio State University who beat Notre Dame this past weekend on the final play. So Pearl will be smiling continuously during this podcast. But we welcome you. Pearl's going to be co-hosting the Legal Truth podcast, and we're glad to have you part of the team.
Thank you so much for that introduction. I'm so excited to be here. And most importantly, I'm excited to talk about the real value of your claim.
That question, what is the real value of a claim, is probably the most common question I get. And you get it from the beginning of the case. If you watch TV lawyer ads, everybody's talking about getting you the money you deserve and the real value of the claim. And so I'm glad we're addressing that question because that's a big question for the public.
Absolutely. So first off, what factors should be considered when determining the value of a personal injury claim in South Carolina?
There's a lot of factors. The first thing is to define what the real value is. Out on the street, people think it's 2 times your medicals or 3 times your medicals, which is absolutely wrong. There are hundreds of factors that determine the real value of a claim. People come in, they meet with me the first time, and they ask me before the case even gets started, as far as the construction of the case, what do you think the value of my claim is? They ask it again when insurance adjusters offer a settlement and they want to know, well, is this the real value of my claim? They ask it again if we're trying to decide whether or not we need to file in litigation and file a lawsuit. What is the real value of the claim? And then they will ask it again before we go to trial. Are they offering the real value of the claim? So first you got to define what real value is. And here, I define the real value of the claim as what would the best jury we could pick in a particular county award in a case if we presented every fact that existed that increased the value of the claim in a presentation model that the jury would like to hear. So that's our backdrop. If we go out and investigate all the facts, build the best case possible, what would a jury in the county in which that case is pending, what would they give us? Mm. And that's the real value. It's not 2 or 3 times the medicals. It's really a lot deeper than that. I think of what we do is like building custom cases, just like you build custom homes. Mm-hmm. And if you think of it as in the construction world, it would be like me asking you, what's a 2,400 square foot house worth? When that's all I know, it's a 2,400 square foot house. Well, it depends. It depends on what county are you building it in. Do you have a custom home builder who has a reputation of building high quality homes? What elements does he have to work with? I mean, are you buying marble countertops? What kind of flooring, what kind of walls, what kind of lighting? What's the elements that he's adding to the project? And who is he using as subcontractors to install the elements? And it's the same thing with building cases. What's the elements of a particular case? And every case got different elements or facts that surround every case. It comes down to facts about the plaintiff, about who they are, who they've been in the past, facts about the defendant, who they are, who they've been in the past, what happened at the wreck, what happens after, or I say the wreck, or after the incident, what happened at the incident to cause the injuries, and then what has happened since the incident. So there's hundreds of factors that determine the real value. Just alike, just brrr, and they go up in 3 months. That's not what we're doing.
Okay.
What we're doing is building custom cases based on the elements. If you think about a custom home, you want a custom home builder, someone who's got some experience, know what they're doing. The value of that home is going to be determined by who builds it, what's the elements they put in, how valuable are the elements that they put in, where is it built? Is it built in Horry County, Charleston County, another county away from the beach? The county determines the value. The subcontractors who put in the elements. A custom home will be more valuable if an experienced marble counter installer installs a counter than if I try to do it myself.
Exactly.
So the installer matters. The items matter. You think about a case, the first thing we do is try to find every element that we can put in this case that adds value. So the first thing we're doing is investigating everything.
Okay.
We're looking for elements that increase value of the claim. And there's hundreds of them. It's not 2 or 3 times the medicals.
Right.
That's cookie cutter.
Yeah.
Is the plaintiff someone who's been good to society that people like, that has value to society? What's the plaintiff's background? What's the defendant's background? Is this the 3rd DUI that the defendant has had? Have they contributed to society? Both of those things make a difference in the eyes of juries.
Okay, so maybe someone's character could be like the marble countertop in this analogy.
That's right.
Okay.
Or a cracked marble countertop.
Right.
But you're right. It's the details. The installation process is the difference between a plaintiff saying my neck hurts and you having a reputable doctor who shows an image that proves an injury, and then that doctor is able to explain to the jury, this is what's causing the neck pain. This is why it hurts.
Right.
What the plaintiff is saying is consistent with this injury. Well, the same element's been given to the jury, but it's been given in 2 different ways, the plaintiff or through a reputable doctor.
So what I'm hearing you say is that with each of these custom cases, there's going to be a different outcome. So there's not really a set way to determine the exact number that a client might get.
That's correct.
So going forward, when we're looking at these personal injury cases, what might the severity of the injuries kind of do to the amount that a client might get in the end?
Well, the severity of the injury is a big factor. It's a big element. It is kind of the foundation. If you think of a custom home, what's the square footage?
Okay.
Does somebody have a sprain, 1,500 square foot? Or do they need surgery on their spine in 2 spaces because they have herniated disc? That's going to be a larger footprint. So that is kind of the foundation upon which you build the case. You think of it, someone comes in, they've been injured, and they have a spine injury. The first thing we want to do is find out what the diagnosis is and what the imaging shows.
Okay.
And then we go backwards. We go backwards in time to look at medical records to see if there's any prior complaints, any prior problems. Because if there isn't, then that injury, the causation of that injury is a lot clearer to juries. If there is prior problems, then we want prior imaging to see how it's been exacerbated or worsened by this incident. But that I would think of the injury as the foundation of the case that we're building. We're looking back as far as causation, to prove causation, that this injury was caused by the accident or caused by the incident. We're comparing priors. We're then leaving the injured party and his or her doctors to do their thing. We don't get involved. We want the doctor and the client to take care of the health problems and the injuries and just give us reports as far as what's the diagnosis, what's the prognosis, what's the future look like.
So now that we kind of have these medical records from our client, what do you kind of do going forward now that you have that foundation of the case of how severe the injury really was?
Well, the value of your claim is determined by three major components. When I was in law school a long time ago, when we rode horses and buggies to law school, I was taught that the value of a claim is you have to look at it like a three-legged stool. You have the liability leg, you have the damage leg, and you have the collectability leg. And like any three-legged stool, if you don't have solid three legs and you sit on it, if one of them's weak, you fall. It breaks and you fall. So someone comes in with a significant injury. If that injury was caused by the incident, you have the damage leg, and you're trying to determine how is that injury, if and how is that injury going to affect somebody for the rest of their lives. That is a big factor in value. The liability leg is how strong do the facts make it that it was someone else's fault.
Okay.
And someone violated conduct that's recognized in the state of South Carolina as being a wrong that you can collect for. The state has to have elements that you have to prove in order to even get to the damages. In torts, car accidents, you have to show that the person had a duty, they breached their duty, the breach caused damages. Duty, breach, causation, and damages. In a premise case, you have to show that the premise owner knew or should have known there was a defective condition on the premises.
Okay.
So every different types of case have different elements you have to prove. So you look at the liability leg. It may be a strong liability. You may be riding down the road, someone crosses the yellow line, they're drunk, they come across and hit your family.
It's pretty clear, yeah.
Clear liability.
Right.
That leg's solid. And then the third leg is collectability. Collectability is often a sad leg to have to talk to people about because you can have a good liability case where that's solid. You can have bad injuries or damages, but the insurance coverage is very low.
Right.
Somebody's riding on the road with $25,000 in liability coverage. Our client doesn't have underinsured motorist coverage to protect themselves.
Okay.
The at-fault party has no assets. So you have bad liability, bad damages, and $25,000 to collect. And those are hard conversations because
kind of sad, yeah.
the real value of that claim may be millions of dollars, but if you can't collect it,
what do you do? Yeah.
you don't do it. We can go to trial and get a piece of paper, a judgment against the person that's good for 10 years, but if someone's been damaged bad, that's a sad situation.
Okay, so let's say we do have a case where the liability is clear, someone was really injured, they went to the doctor, they did everything right. What kind of role do medical expenses then play in determining the real value of their claim?
Yeah, like I said, the injury is the foundation.
Okay.
Medical bills, they're an element. Sometimes they're a valuable element, and sometimes they're not a valuable element.
Really?
Let me explain that. If somebody's got, $300,000-$400,000 of medical bills, then that's a valuable part of the damages to come up to the real value.
Okay.
But sometimes somebody has devastating injuries and very low medical bills. If you think about somebody who may lose both legs in an incident, or someone who has a traumatic brain injury, their past medical bills, they pale in relationship to the actual damages in this case and the
Okay.
life change in this case.
Mm.
So sometimes medical bills are a big element in coming up with real value, and sometimes we don't even present them to the jury because you risk the chance of the jury kind of anchoring down on a low medical bill when the medical bill is nowhere near the most important parts about the case.
So let's say medical bills aside, let's say I couldn't work due to this injury. What kind of compensation can I recover in an instance like that?
Well, in South Carolina, you can get the medical bills,
Okay.
both past and future medical bills you
Okay.
can get. You get future medical bills if you have a doctor to opine that based upon a reasonable degree of medical certainty, it is more likely than not that you would need these future medical procedures. The law also allows that an injured person can collect past lost wages
Mm.
and future lost wages.
Okay.
The future has to be proven. We use vocational experts who will often assess our clients' abilities, their past work history,
Mm.
and then look at the medical restrictions given by doctors to determine whether or not that person is employable in the future.
Okay, absolutely. And so maybe while this client is missing work and they're kind of trying to account for these lost wages, there's also an emotional and mental part that comes into play, right? So how do you kind of assess those damages and, determine what kind of compensation they might deserve for that?
Yeah, one of the elements allowed in South Carolina law is mental anguish and emotional damages.
Mm.
You know, that element is tougher.
Right.
That element, you really need to have that subcontractor we talked about as far as presenting that element.
Yeah.
You need a credible person to be able to come up, and it's often done with lay witnesses. Sometimes
Okay.
it's done with professionals if the emotional damages are bad enough.
Mm.
But often those are your good friends, your coworkers, your family members who've seen a change and see what you're struggling with.
Okay.
Most people don't like to go out and announce they're having emotional
Of course
stress
not.
and mental
Yeah.
anguish about something. So it takes people close to the individual. And because that's something that could be true or not true, the credibility of those people that your witnesses who can
Mhm.
explain that to a jury, their credibility is very important.
Right. Absolutely. So what I'm kind of hearing you say is that it depends on each case. Like you were saying, it goes back to that kind of custom house analogy where, you know, in one particular case, you might have a lot of witnesses that are super credible, but sometimes it's just kind of hard to prove.
That's right.
Yeah.
And if you think about it, the mental anguish part about cases, I can tell you that as a society,
Mm.
we recognize mental health and mental anguish a lot more than we did 20 years ago.
Right.
20 years ago, it was a very small part of any kind of personal injury
Really?
case.
Mm.
But I think just the public is much more aware of mental health problems today than they were 20 years ago.
Absolutely. So kind of turning back to a different kind of case, let's say, you know, in terms of property damage, what is kind of the process for valuing that in a personal claim?
Property damage is a frustrating thing in South Carolina. We can handle a huge personal injury claim with less hassle than property damage claim.
Really?
It is frustrating. And the frustration comes from the law, what it allows for and what it doesn't provide for. In a car wreck case, if your car is not damaged, it's not totaled,
Okay.
you can repair it for less than 75% of the value. It's not total. South Carolina says you're entitled to the reasonable amount of money to have it repaired, the reasonable amount of money to store it
Okay.
while it's being repaired,
Right.
loss of use to substitute that car while it's being repaired for something for you to drive,
Right.
and then depreciation of the car because of the wreck, because we all know that Carfax, and I'll tell you, if your car's been wrecked.
Absolutely.
So you're entitled to those. If the car is totaled, you're entitled to the actual cash value of the car.
Okay.
That really stings for people who have a dependable car. They've taken real good care of it. They got some age on it. It's paid off. They don't have any payments.
Right.
Then by no fault of their own, somebody comes across
By happenstance.
totals the car. When you look at the book value or you talk to a car dealer, it's only worth blank dollars. And now they only have blank dollars to go out and try to find a dependable car. And that's tough.
So would that value that they're maybe given, like that blank dollars, are you saying that that's typically way less than, what they paid for it originally?
Oh, it's always way less.
Okay.
And if they've got it paid off and they've been driving it for 5 years and taking care of it,
Right.
that value has dropped. And when you drive off the lot, it drops, but it drops, every year and every mile you put on it.
Right.
So the people who have dependable cars that have paid off, it's not a good thing for them, what the law provides. And oftentimes, if the at-fault driver in a situation is either not talking to their insurance company or telling a different story to their insurance company,
Oh,
the insurance company may not be willing to repair your car.
really?
And that may be contested. In that case, you better have some collision and comprehensive insurance on your own policy so that you can take care of it and let your carrier go back against their carrier to get repaid. We've had some clients who only have liability coverage. They don't have anything on their own car.
Oh.
And in that situation, they're without a car until we can litigate it or prove to them they should pay for the property damage.
So obviously one of the factors you're saying here is whether your car gets totaled or there's kind of some lesser damages or things like that. Are there any other kind of pertinent factors that people need to consider, if they happen to get in a wreck or they experience property damage?
No, you have a duty to mitigate your damages.
Okay.
What that means is you have a legal duty to reduce your damages as much as possible. One of the rubbing points with property damage is the car will get towed to a storage place. The at-fault driver's insurance usually pays for that.
Right.
But now the at-fault insurance company is delaying making a decision whether they don't pay for it.
Okay.
It sits there and it's getting storage charges,
Oh.
a daily storage fee.
Right.
After a short period of time, if there's a place our client can put their car, we try to remove it from that. If our client doesn't have a location to put it, then they can't do a whole lot to mitigate that damage of storing a vehicle. But the storage charges, to getting people in a car, that's a frustrating part of property damage.
And is there typically like an allotted set of time that an insurance company would have to respond to make sure that these storage fees are taken care of?
No, worst case scenario, an insurance company can say, we're denying liability, so we're not paying your property damage.
Gotcha.
And so to receive those damages, you'd have to file a lawsuit. And that takes a while. It takes about 13, 14 months to come up on a roster.
Wow.
South Carolina does have a process where you can file a property damage claim.
Okay.
It's a non-binding arbitration. They put 3 attorneys in a particular county to listen to it, and they come up with what they think the value and what the decision should be. We've done that a few times. That's not the best situation.
And why is that?
It's just not binding, so the insurance company can still keep fighting it. It has got some cases settled when there's just a dispute about some of the storage stuff and about the depreciation, where they have a disagreement about depreciation.
Okay. So kind of going back to maybe our car wreck scenario. Let's say I was driving my car, I get injured, but maybe I'm partially at fault. So what does comparative negligence kind of do to my personal injury claim?
Well, you can't work for the Derrick Law Firm if you're stirring up litigation, Pearl. Be careful.
Oh, no.
No, we have comparative negligence in South Carolina. It's not true comparative, But what the law says is that if your fault becomes greater than the other party, you collect nothing.
Really? Wow, I bet that can be devastating to some cases.
Yes.
Yeah.
Now, when I got out of law school, it was contributory negligence,
Okay.
which said that if you were 1% at fault, you can't collect nothing.
Oh my goodness.
That still exists in North Carolina, which is a terrible law.
Wow, yeah.
I mean, they would argue 1% fault because you got up and got on the highway.
Right.
So, but comparative, if your total damages in your case is $100,000,
Okay.
and a jury finds you 50% at fault and the other party 50% at fault, you can collect $50,000 of that 100.
Okay. So that's
Your
still,
100
yeah.
is reduced by 50%. If you're 25% at fault, it's reduced by 25%. But if you're 51% at fault, you get nothing.
No way. So that 1% can really take you over the edge there.
It's yes, it can.
Wow.
And that's when we're investigating these cases. And really the most important thing about getting real value of your claim and determining the real value is a fast, thorough investigation. I tell our attorneys, I want to know everything. I want to know the good, the bad, the ugly. I want to know everything. Because every little fact counts.
Right.
And we may be in a situation where we're fighting for that 1%.
Yeah.
And so I want to know everything. We jump on, we have private investigators on standby. I think we've got 6 or 7 of them now. I want to investigate within 24 hours. I want pictures of the skid marks. I want pictures of all the cars. I want to talk to every witness. I want to pull the data from the at-fault party's vehicle to see how fast they were going.
Yeah. Everybody's
got computers in their cars now. We can get a lot of good data.
Yeah.
I want people on the scene looking at surveillance of homes or businesses close to the incident.
Right.
The importance of getting all of those facts so that you can prove 100% on the part of the defendant, or get every piece of evidence that you can put on your side of the scales to weigh it down.
Right, because that can be that 1% like you were talking about.
It's amazing how evidence disappears. 20 years ago, if you get in a wreck, 10 people stop, make sure the person is okay, and leave their names and numbers. Hey, if you need, I saw it, call me.
Really?
Those days are over.
Yeah.
There can be a wreck out on 501 in front of Tanger Outlet, and there's no witness.
Yeah.
And so it's harder to get witnesses nowadays because people just kind of move on with their lives.
Right.
I tell family members when something happens, I really wish some family members step up and say, hey, let me call somebody and get this investigated while you're mourning or while you're taking care of these injuries, because time erases evidence. And if we can get on a case early where I can pour surveillance. And the problem is these surveillance videos, they overwrite themselves.
Okay.
So it may be 7 days, it may be 3 days, it may be 30 days, but the evidence disappears.
Really?
The witnesses disappear.
Yeah.
Who was working at the store next to the scene, who went out there and talked to everybody.
People forget.
They forget.
Yeah.
They change jobs. They leave the state.
Right.
The difference, and I'm gonna tell you, 20 years ago when I was in practice by myself, I was the only attorney, small firm. I could not afford to do what we do now in the cases that make huge differences. We now investigate immediately to get those facts. And unlike the woman who called me, I mean, she doesn't call me and those surveillance they get gone.
Right. They disappear.
It just gets to be a much harder case.
Right.
And it's the timing of getting someone to investigate the case is probably the most important thing that the plaintiff or the plaintiff's family can do.
That's good to know. So what steps can I take to maybe maximize the value of my personal injury claim? I know that we talked about, timeliness being key and that being really, really important. What are some other things that really contribute to getting that claim number faster?
I would, and we ask our clients to cooperate with your lawyer. There's things that people do to destroy or weaken their case. Number one is to lie about anything.
Right.
If you don't tell the truth,
They can't help you.
somebody's going to find out and you wreck your case. So to be honest is number one.
Okay.
Number two is to do what your doctors tell you to do. You need to be honest. You need to do what the medical providers tell you to do. And other than that, just live your life. I mean, the things that have happened up until the incident and at the incident, there's nothing you can do about that.
Yeah.
Be honest with your lawyer so we can go investigate it and get everything pulled and know the things that add value and the things we need to work on.
Right.
After the incident, the plaintiff is actually part of building their case because everything they do after that is evidence.
Really? Okay.
So you think about, we've had cases where at-fault driver hits one of our clients and he immediately he starts FaceTiming and saying how bad he was, and somebody pulled out in front of him and blah, 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 blah on FaceTime and on social media.
Yeah.
And we made some hay with that.
Right.
So you have a person who's injured in a wreck, they jump on social media.
Mm.
Everything you say on social media is discoverable.
Right.
You can't erase it. You can't erase evidence.
Mm.
So when you jump on social media and share everything with the world,
Right. It's going to come back to you.
You get the good and the bad, and most time it's the bad. We advise people to just get off of social media.
Right.
Not for their entire life,
Mm.
but you just don't need to discuss anything out about the incident or anything. It's creating opportunities for the other side to attack you.
Right. And would you say that juries kind of pick up on the type of character of a plaintiff or defendant if they are posting stuff on social media that may be rash or things along those lines?
Absolutely. I mean, there's no doubt about that.
Yeah.
One of the first things we do investigating people is social media.
Mm.
I mean, somebody gets in, the at-fault driver gets in a wreck, we're going to look at their criminal record. We don't look at the social media and just get all kind of stuff. I mean, we get videos of somebody bragging about riding down the road while they're high.
Oh, Lord.
That's pretty good evidence.
Yeah.
So it's amazing to me, and maybe I'm just an old man, but it's amazing to me what people put on social media.
Absolutely.
But nowadays, they share some things.
Everything
that they should not share. But if you're injured in a wreck, understand that everything you're doing, if you're injured in any kind of incident, understand that everything you do after that until the case has concluded is evidence, discoverable.
Right.
And that's what insurance companies look for. That's what defense lawyers look for. They're looking for just something to hang their hat on. So people need to know that.
So would you say overall, when you're building this custom case, what's most important is calling as soon as possible or getting somebody else, maybe in your inner circle to call, B, making sure that you're being honest with your lawyer, and then C, watching what you're doing on social media and being careful about what you're disclosing?
I think so. I think investigations faster. We've got to get the facts. When I was growing up, there was a TV show called Dragnet. You ever seen Dragnet?
I have not.
Okay. And there was a line at the first of every show said, "Just the facts, ma'am." The facts are what determines the value of your claim. The facts. So if you get a fast investigation where we jump on it and we can get all these facts fast, we've done the most we can do with the facts. The facts after the incident, as developed by the plaintiff and the plaintiff's conduct, those are what determines the value of the case.
Okay.
Like I said, we do a lot of focus groups.
Right.
It used to be for the first 30 years that I practiced law, somebody would come up and say, what's the value of my claim? If they come into my office and say, what kind of value do I have in my claim? I say, I have no idea.
Yeah.
I've heard this much of the evidence. I've heard from one side. Have no idea.
You need all the details and all the facts.
All the facts. After we get all the facts, what we do now, we've been doing the last 4 or 5 years, we'll get all the facts, and then we'll do a focus group jury research project where we bring in 12 people. We don't tell them which side we represent, and we present the facts that are good for the plaintiff, the facts that are good for the defendant, and let them deliberate and tell us what's valuable and what's not valuable, and what they think the value of the case is, and what additional facts they would want if they were on a real jury. We take what they tell us and go get those additional facts. And so we're able to show our clients what these 12 people say the real value is. And before we did that, we're just guessing.
Right.
As a lawyer, we're just guessing.
You never know.
You don't know. What lawyers know, if you don't use real people, what lawyers know is what insurance companies will voluntarily pay.
Right.
And that's not our definition of real value.
Okay.
Insurance companies have a duty to their shareholders. They're trying to make them money. I have no duty to their shareholders. I have a duty to my client to find out what the real value is. So to say this insurance company will only pay blank dollars has no relationship to what the real value of the claim is. They're paying out a risk. They're weighing their risk rewards.
Right.
And the better you can build the facts, and then you get an appraisal from a focus group. And we often show the appraisal to the insurance company, to the defense lawyer, and say, hey, that's what these 12 people, you need to get your money up. Here goes what the real value is.
Right.
There's a lot of cases. People think it's funny because I'm an attorney, and I think there's a bunch of unnecessary litigation. But the reason there's unnecessary litigation is there's no way to determine the real value of a claim until it gets to a jury.
Right.
And often that jury's 3 or 4 years down the road from when the incident happened.
And you still never know what they might say.
No. So you build the facts, and people are disagreeing with what 12 people in a particular county would do with those facts as far as value. So what we've done with our jury research is we've taken this thing that happens 3 years from now, and we'll actually focus group the case before we file a lawsuit.
Okay.
If we can get the majority of the facts, focus group it, see what they think the value is, so we can tell our clients, so they can make a decision whether or not they want to file a lawsuit, or if we show it to the other side, if they come up into an acceptable range for our client, the client can make a decision. Well, based on what these 12 people say, I want to take that, or no, I want to drive forward and go into litigation.
So out of all the juries you've seen, have there been particular factors that keep coming up, or things that juries say that I just always wanted to see more of this or this? What are some of those factors that can really kind of determine what a jury needs to see?
Well, they tell us bluntly. Juries want to see stuff. They don't want to hear about it.
Right.
They want to see the imaging.
The evidence.
They want to see the evidence. They need someone to give them the why. It's just not the what. A doctor can say, she's got a herniated disc and she's got a permanent impairment. But they want a doctor who tells them and explains to them, she has a herniated disc. Here goes the imaging. Here goes a model of it. Let me show you what that herniation has done to her spinal cord or to her nerves coming out of her spine. Let me show you why when she says she's having symptoms in this region, this is why she's having symptoms in those regions.
Okay.
Here goes why we have to fix it. Here goes why after we fixed it, she may have some degeneration on this level and this level, because this medical journal and this study shows that when you fuse this section, these two sections get a lot of wear and tear over the next 20 or 30 years. So they want to know why.
Right.
They
want to see the correlation between perhaps the accident and what the doctor is saying.
That's right.
Okay.
They're you got to show them. They want to see it. They want to feel it. Got to explain it. They want to know. They want good, clear evidence on causation.
Mm.
When we all start walking, you start wearing out.
Oh no.
You start getting old immediately. You get over 30, 35 years old, you start getting some wear and tear in your spine. They call it degenerative disc disease, but it's wear and tear. I've had a lot of people come in and say, oh God, the doctor says I have degenerative disc disease. I say, hey, he's just saying you're wearing out.
That would scare me.
Yeah. So they all have a cousin or an uncle or a spouse who has back problems or neck problems.
Kind of that blanket statement,
from wear and tear of life.
Okay.
So the doctor really has to explain why this is not something that happened from life. It's because someone was negligent or reckless and caused this injury. So if they can do that, they can teach what happened. They can teach why they know that's the case, why they're giving an opinion that this was caused by the incident. They want to know the same thing that we would want to know if we were on a jury.
Right.
So you just have to give them the evidence they want. The focus groups are tough on plaintiffs. Okay. They don't like to hear plaintiffs whining about their condition. I think human nature, from a psychology standpoint, if you sit across the table with somebody and they tell you I'm hurting or I can't do this, I can't do that. Unless their arms falling off, you don't.
Right. There's like an air of skepticism that kind of goes along with being in a jury.
That's a very nice way of saying it. Yeah. But they are skeptical.
Right.
And they won't. You got to have more than your plaintiff talking about it. I don't like the plaintiff talking about it very much at all. I like the doctors to explain the injury. Right. To explain the causation. And then we're looking for the people closest to the plaintiff at home and at work who have seen the plaintiff both before and after the incident to explain the change. And those people, some of the most believable witnesses to determine the value and to set the value. Those subcontractors I was saying about who puts in the element. If you get a coworker or supervisor at work, they're very believable. Okay. If you get people who know you but don't have a dog in the fight, who are credible, they make good witnesses. Okay. We had a ex-mother-in-law in one case, which was an awesome witness.
Very interesting, yeah.
So people who don't have a dog in the fight and people who don't,
third parties
aren't going to benefit from whatever the jury decides, make the most credible witnesses. Right. And then again, the other thing we found is if you don't do what the doctors tell you, if you're not making an effort,
people will notice.
Everything possible to get better, you'll get punished. And people have, and to be fair with people, people are going through life. Right. It takes a lot of effort, and you can lose wages to take half a day off and go to a physical therapy
Constantly
session.
scheduling and making appointments and finding the right doctor for you.
That's right. And they're still trying to live on their budget and still trying to make money at work. Right. So there's a lot of legitimate reasons why people have a hard time doing exactly what the doctor wants. But it better be a good excuse. Or the focus group or the jurors. There'll be members of any jury who punishes you for it. Yeah. I've been surprised on how quickly the public has forgotten about the COVID scare of 2020.
Right. Yeah, it's very much active.
Everybody had to quit treating.
Yeah.
Doctor's offices closed. You go to the hospital, and we have some older cases that got pushed back because of the courts closing that have finalized over the last year. And I've been surprised when we focus them, people are saying, well, I should have still gone to the doctor.
Right.
Well, the doctor's was closed. It was closed.
And there was no way to get in. Yeah.
Everybody was scared they're going to get COVID.
Right.
So we forget pretty quickly.
Absolutely. So kind of wrapping up with jury research focus groups, where would you say you can kind of place these focus groups in terms of our house analogy from before, our custom case? Would you say it kind of caps off this jury experience or this case experience, or?
Well, the focus group, they're the appraisers. We have a podcast called The Appraisers where we share case studies with other attorneys around the state of South Carolina.
Yeah.
But they are the appraisers. When a custom home builder builds a home, he can put a price on it. But if somebody's on buy it, they don't go to the bank. They can get an appraisal done. A professional appraisal to come in and determine the value of that house in that location. That's what the focus group is.
Yeah.
The focus group is not me appraising it because I love my client.
Right.
It's not what my client thinks the case is worth. It's not what the insurance company thinks the case is worth. It's not what the defense lawyer thinks the case is worth. These are 12 people who don't have a dog in the fight, 12 people who are unrelated to anyone in the case to come in and say, in our community, based on these facts, issues, and damages, here's what we think about the case. Before we did focus groups, at every step of the way, insurance company makes an offer, said, this is all we're going to pay you. Dirk, what do you think about the offer? Well, I don't like the offer. Well, what's the value? Well, I think the value may be more. Let me go look at what John Doe got in a case 2 years ago against Jill Doe, the other attorney, on different people with different facts and different elements presented in different formats.
It's not as helpful.
It's apples and oranges.
Right.
There's a trial consultant that says if you give a case to 4 groups of 6 people, you'll get 95 or 98% of the conversations that go on in the real jury room. We often do a pre-lit focus group, and then we do another focus group after we get the evidence in before mediation. Then we do a all-day focus group for trial. So when we're going in, we've had 6 groups of 6 tell us what they think about evidence and what they want to know. So we feel like we're incredibly prepared when we go in. One of the benefits we have found, and everything we do is based upon no one wants to file a lawsuit.
Right.
Everybody wants the real value. They want it now, and they want top quality customer service.
Right.
So anything we do at the firm is based upon one of those things.
Yeah.
These focus groups have allowed us to get juries' opinions before lawsuits filed, to share the values given from those focus group panels with the other side to try to expedite the resolution of the case.
Right.
It's been successful in a lot of cases. And I believe it's the best thing we've done to get real value for our clients, to know what the real value is and get it in an expedited manner.
So what I'm hearing you say is that jury research focus groups are kind of a way to have the trial experience without having to go through a ton of unnecessary litigation. So I know that you said that clients really benefit from this process. What is the benefit to the attorney who has this case, who's focus grouping this case?
Well, it's huge. When I got out of law school way back then, we tried cases all the time. We were always on a trial roster.
Right.
We were always up at the office on the weekend getting ready for a trial. I mean, we just tried cases. We didn't have arbitration, mediation, all that stuff. We tried cases.
Right.
And we constantly got the feedback from the community as far as what they believed about issues, facts, and damages. I wouldn't need focus groups if we were trying that many cases, but cases don't try anymore. We win cases now in discovery.
Okay.
But you must be prepared to try the case if the insurance company makes you try the case.
Okay.
So our attorneys are able to stand up over and over and over and present cases to jurors
Right.
in the focus group arena, get immediate feedback, watch themselves on video, make changes to presentations.
Right.
There's jurors who are awful jurors for the plaintiff in a particular kind of case,
Okay.
and great jurors in another kind of case.
Right.
Good jurors with this presentation model, bad jurors if you don't use that presentation model. So the focus group allows the lawyers to learn what they want in this particular case, to see whether or not any problems they have with the case is fixable.
Okay.
There's some things fixable and some things aren't fixable.
Right. That are out of your control.
We had a case that we focused not too long ago that there was a fact. We knew it was a bad fact. We're trying to see whether or not all the other facts overrode it
Okay.
to get our client
The best value.
up to a 50-50 liability situation.
Okay.
12 out of 12 focus group members put 70 to 80% of fault on the client.
Oh, wow.
And when we talked to them afterwards, they said, there's nothing you can show me that
would
will
change
make
my mind.
the other party more responsible than your client.
Wow.
So, on the one hand, you don't want to hear that.
Of course.
On the second hand, you now can show your client what they think about that fact now versus 3 years of litigation and cost
Right.
and dragging your client through all of that. And then they find out at the end when they walk out of a courtroom that they lost because of the fact that we couldn't do anything about.
Right. So it can kind of help give them that realistic view of what they might get if this case did end up going to trial.
Absolutely.
Yeah.
And we got that case worked out
Good.
for what was a decent value, especially knowing what we knew. And so it gives our client that information. We've actually had some of the some clients who've been happiest with us is when the focus group tells them it's worth here. We've already got an offer up here, and they take the money because we'd have lost money if we'd have moved forward.
Yeah.
There's chances we don't lose money by going forward. So
Right.
it helps speed up the process, prevent unnecessary litigation, and speed up necessary litigation if everybody knows what the real value is as early as possible.
Well, it seems to me like these focus groups can really help everybody, like from the attorney to the plaintiff. But my question is, how do these focus groups kind of aid jurors? Like, what do you guys offer to jurors who want to participate in a focus group?
Hey, people love it. I mean, it's I think we've had about 6,000 people sign up.
Really?
It's
a lot.
I think 2,500, 3,000 have served.
Wow.
Over that, 95, 96% of them sign up. They want to serve again. People like having a voice in the community standard.
Yeah.
And I mean, they come in, they serve, they get some good suppers, a nice piece of cake, and they get to have a say-so and make a difference in a case. I mean, what they do very often affects everybody who's involved.
Absolutely.
And they like it. There's some people who come who've never been picked for a jury, and I've always wanted to be on a jury. And people like the law. You know, they watch the criminal cases on TV and get into it, so they like to come in and
have their legal experience.
have their legal experience. And it's good to get a wide variety of opinions and what people want. It helps our attorneys get ready for trial. If they have to go to trial,
Right. Good practice.
They are as prepared as they can be.
Absolutely.
Comparative negligence in South Carolina is you compare the negligence of everyone who's involved.
Okay.
And as long as the plaintiff was no more than 50% at fault, if you compare all the negligence, then they can recover. Their damages are reduced by their degree of negligence.
Okay. So if they were partly at fault, that might kind of mean that they could lose value in what they get.
That's right.
Okay.
We look at that. I mean, if it's a 100% case or a lot of times on trip and falls, slip and falls, there'll be discussions in the jury and in the focus groups about, well, plaintiff was partially at fault. She had on flip-flops. So
Yeah.
she was 10% at fault. So when they come up with damages, if the damages are $100,000 and they thought she was 10% at fault for wearing flip-flops in a restaurant, then she would only collect $90,000.
Okay.
Contributory negligence is a doctrine we had when I got out of law school, which is now still in North Carolina,
Okay.
that says if the plaintiff is 1% at fault, just 1%, they get nothing.
Wow.
It's a harsh law that is not in a whole lot of cases.
I bet that can really damage some cases.
Oh, I mean, 1%.
Yeah.
1% is not hard to find.
Even a little bit. Yeah.
Just a little bit. You know, if you go in 42 and a 40, and somebody pulls that in front of you, can they say you were 1% at fault because you're 2 miles over the speed limit?
Maybe.
Yes. So that's a harsh law. Thankfully, it's not in South Carolina.
Yeah, absolutely. So I know that you put such an emphasis on getting all of the facts of a case. So how do you really do that? Is that just part of the in-house investigation, or are there other parts that kind of come into play?
It depends on the type of case it is. You know, to get the real value, you need to get the facts. You need to get,
Of course.
good, bad, ugly.
Yeah.
For the first 30 years of my practice, or at least the last 20 of those 30 years, when you talk to the insurance company, they would say, well, we think your case has problems. You know, because of A, B, C, and D, we don't offer you this. And the older I got, the more I'd say, listen, I don't want to hear the problems in my case. I'm old enough to understand them.
Of course.
Just tell me what you don't pay me. And I've now changed that. And I've told our attorneys, now you listen to them and you say, tell me every reason you don't think this case is worth what we think it's worth. Tell me every argument you have,
Right.
every piece of evidence you have, and we get them to tell us that so that we can then use it in the focus group and make their arguments with their evidence to these focus group members to see what they have to say about their arguments.
Or perhaps make your case stronger, I'm assuming.
Absolutely. There is nothing better than sending a focus group result to an insurance company who, when those members of the focus group jurors have killed the arguments they've made at us on the telephone. So we can do that in car wrecks, that kind of case.
Okay.
We get it from the insurance industry a lot of times. And then if it goes in litigation, we'll get it from the defense lawyers too. And then when they start taking depositions, you start picking up on what their argument's going to be.
Yeah. So maybe in
what
some
their
different
theory
places.
of the case is.
Okay.
There's some cases, if we can get most of those facts from the insurance, we can focus this stuff before we ever have to file a lawsuit and speed up the resolution a lot of times.
Right.
There's other cases you can't do that.
Okay.
Let's say it's a premise liability case where someone falls inside of a business. They have surveillance. Let's say it's a bar, they have surveillance. Something happens, there's incident report, there's witness statements. We say, hey, how about give us that? And they say, nope.
Sorry.
Because they have no legal duty to give it to you if there's no lawsuit going on.
Oh, so you have to file the lawsuit at that
So
point.
then you go to your client and say, listen, the facts that they have, the facts they know, have a chance to change the value of this case drastically.
But
we've got to file a lawsuit.
yeah.
And like I said, nobody wants to file a lawsuit, and no one wants to be sued, but they won't give us the facts to evaluate. That's the only way you do it. You can't properly evaluate a case when there's facts you don't know. It's like that in trucking cases.
Yeah.
Did they properly hire the right trucker? Did they violate their own policy? Did they train them right? Or
There's a whole commercial aspect to
the
it.
whole commercial, the regulations.
Right.
They will not give you that without litigation. You have to go file a lawsuit. Same thing with dram shop cases. We do cases against drunk drivers and the bars that overserve them. They get out on the road and kill people or hurt people.
Right.
What we want to do in that, we want the facts we get on that. We get the dash cam out of the police cars, the vest cams, the body cams on the police officers, if we can.
Are they supposed to give that to you, or how does that work?
The dash cams we get,
Okay.
a lot of times they won't give us the body cams until there's litigation.
Oh, so same thing kind of as
Yep.
some of those other businesses.
We want surveillance. We want to do everything we can get from the time of the wreck to prove the intoxication level of the driver, but also find out if they're coming from a bar that overserved them.
Yeah.
A lot of time the dash cam, you can pick up, sometimes they talk about where they come from, if the officer questions them.
Right.
But those cases usually require us to file quickly because it may surprise you that surveillance disappears
Oh, really?
pretty quickly in that incident. We want surveillance. We want the credit card receipts when somebody goes into a bar and drinks to see what they purchased.
Right.
We want to know who's working that night.
Mm.
Won't just know all the facts, and they won't voluntarily give it to you. So your only option is to file suit and
Right.
go in and do discovery. When I say file suit, what I'm talking about, when you file suit, you now have the ability to subpoena things. You now
demand.
have the ability to make them sit across the table from you and you ask questions. You have the ability to make them produce credit card receipts to you, make them produce the surveillance to you.
So while they're maybe withholding such receipts or footage or things along those lines, is there a particular reason? Are they just kind of hoping that you won't file a suit in that case, maybe?
I'm trying to put it real nicely. They're playing defense.
Okay.
And we're playing offense.
Right.
Also, a lot of I know of some circumstances where insurance companies have kind of given directives to this is what to do when this happens.
Don't say yes, perhaps.
Preserve this, get it to us, give us these things. Don't say anything to anybody. Don't give anything. So there's been some situations where I've seen insurance companies kind of directed people what not to do and what to do. And if you understand it from their standpoint, now their standpoint is they don't want to give facts. They're going to increase the value to the plaintiff.
Right.
So they sit on it until legally they have to give it to you.
Okay. Right. So unless you subpoena those things, in your lawsuit, chances are you might not get those.
Oh, that's right.
Okay.
Understand, it's almost like playing chicken. You offer a person blank dollars. Oftentimes our injured parties will get offers immediately after the wreck. We'll pay you blank dollars, sign our release, you'll be finished. Very few facts known at that time. They go hire a lawyer, and then offer something again. And if I'm basing it on what somebody else did on another case and I don't have all the facts, I feel like I'm not doing my client a good job. I think we've got to find out what the real value is.
Right. And that has to do with all those details and facts that might not come up unless.
All the details. Yeah. The longer they drag out, the more leverage they put on plaintiffs. I call it the leverage of time.
Right.
They've always had, for the first 30 years, the insurance industry has had on our clients the leverage of time. How can we drag it out, hold on to the money? We've got that money invested somewhere. We're making money on that money.
Yeah.
The leverage of time. People get tired.
Right.
Want a case over.
Just want to get it over with.
They go through some hard times. They can't last but so long. They've always had the leverage of uncertainty. You don't know what a jury's going to say about that.
Right.
That jury could really, you don't know. You don't know how 12 people don't respond to this.
But that's what focus groups seem to alleviate sometimes.
The focus group has flipped those two leverages.
Okay.
Because now the focus group, we can speed up the process and we can take away the leverage of uncertainty. So we've have flipped that, and we're still working on flipping it better.
Right.
I mean, every focus group we do, every focus group that we analyze, we've got more data.
Yeah, absolutely.
And, so we use that data. We use what we find as leverage against insurance companies. Insurance companies in South Carolina have a duty to act in good faith, liability coverages.
Right.
Which means if you're a bar, you have insurance, the insurance company will pay damages up to a certain amount. They also have a legal duty to protect your assets.
Mm.
So if I can show them that the real value of this case is more valuable than all their coverage, it puts them in a situation where now they're if they don't protect their clients' assets, they need to go ahead and pay us our money.
Okay.
So
In order to act in that good faith.
that's right.
Yeah.
So we got more ammunition to give them to act in good faith. In the past, they've always said, hey, we're acting in good faith. We just disagree what 12 people are going to do with these
Okay.
facts. Now we show them what 12 people or 24 people or 36 people are going to do with the facts.
So you kind of have the evidence in that way.
Yep.
I've heard the phrase bad faith a few times. Could you kind of define what that is in terms of an insurance company?
South Carolina has recognized an implied duty on the part of insurance companies.
Right.
They recognize that insurance companies have leverage on people who buy insurance.
Mm.
You know, auto insurance is mandatory. You got to go buy it. You better have health insurance. You
Right.
better have disability insurance. You better have this insurance and this insurance. And they understand the imbalance of power
Okay.
between an insurance industry and one individual person.
Person. Okay.
So what they say is these people pay premiums, and then there's a claim. Insurance company, you got to act reasonable.
Mm.
You can't act unreasonable.
Right.
You got to have a reasonable basis for denying a claim. You got to have a reasonable basis for delaying the payment of a claim. You have a reasonable basis for how you value the claim.
Right.
And so we have used, in our effort to find out what the real value,
Mm-hmm.
the topic for the day, the real value of your claim,
Yeah.
is to do this work, get all the facts, get it appraised, and then use what we have found to be the real value to leverage the insurance companies to act in good faith.
Yeah.
If you put it in the best possible light
Mm.
for the insurance company,
Okay.
they're doing their jobs.
Right.
They're trying to save money for their investors. So we just showing them
Mhm.
this is what the real value is.
With all the facts, all the details, and all the
Yeah.
evidence. Yeah.
If you want us to present anything else, let us know and we'll present it to the next focus group.
Right.
So if we show them that, we're allowing them to see what these 12 people think about it. And hopefully, just for doing the right thing, they'll go ahead and do it. If they continue not to do the right thing,
Or to act in bad faith. Perhaps.
there could be a claim for bad faith. And
Yeah.
what happens is, let's say the insurance company, we show them this focus group, we show them this focus group, we give them all the evidence. They don't believe it. They say,
No.
we're not going to pay you.
Right.
We go to a jury. The jury gives us $3 million, and the at-fault bar has only $1 million in coverage. Well, now he's got a judgment against the bar for $2 million that they could have prevented by paying the policy limits.
Wow. Okay.
So that bar
Changes
owner
things.
could then sue them for bad faith for not protecting him.
Oh, okay. Because they have a duty to protect their client as well. If it's,
That's right.
you know,
Or that
a
bar can
business.
assign his case to us to pursue against his insurance. In return, we won't come after his assets.
really?
Yeah.
Oh my gosh, that's interesting.
Yep.
Yeah.
So that they have that. Insurance companies are always looking at the responsibility to pay the claim, but the responsibility to act in good faith
Right.
based on reasonable information.
But then they also have their clients, which causes a whole other situation.
That's right.
Gotcha. Awesome. So during this podcast, we discussed finding the true value of your claim, and you mentioned 3 major components: collectability, damages, and liability. Could you just give me a quick synopsis about what those mean?
Yes, I can answer that question. Liability is who is at fault, who caused it, how much fault you can put on the defendant versus the plaintiff. Damages are looking at all the damages that are recognized under South Carolina law, and then investigating and looking at every damage that was sustained by the plaintiff in this particular case.
Mm.
And then collectability is how can you pay the damages? It's got to come from insurance or assets.
Okay.
Most cases, I've done it for 35 years. I've had assets involved 5 or 10 times. Most of it is limited by the insurance coverage. The insurance coverage that the other party has purchased and the insurance coverage that you have purchased yourself to protect yourself against other people's negligence or recklessness.
So the truth about the real value of your claim. Would you mind kind of summarizing the 5 or 6 points we talked about here today?
Yep. The real value of your claim is based upon what a jury would give you. If the case was presented with all the facts that added value for your claim in a presentation model that the jury likes, and which includes everything they want to hear. It is not one or two elements. It's not a multiple of your medical bills and your lost wages. That's like the custom home analogy again. It is about building a case using every fact that exists in this world to add value to that case. And then looking at the blemishes in the case to see if they can be painted over or they can be minimized. And then to get the elements of your case and the facts of your case given to a jury by the most credible people available to teach the jury the facts and to share the facts with the jury as your subcontractors. And then you get it appraised by the focus group. And just like an appraisal on a house, you get an appraisal of your case by a focus group to determine in this particular county, this is what this case is worth. And then you leverage that to try to do away with the insurance company's leverage of time and uncertainty to flip the leverage on them by using their duty of good faith to get the client paid the real value faster.
Absolutely. That was really awesome information. Thank you so much for letting me be a part of this podcast. I really learned a lot throughout our conversation, and I'm sure our viewers did as well. And I look forward to the next one.
Thank you.
Thank you for joining us on the Legal Truth Podcast. If you have questions that you would like answered on a future episode, please send them to thelegaltruth@derricklawfirm.com. If you would like to speak to us directly, call us at 843-248-7486. If you find the podcast valuable, please leave us a 5-star review and share the legal truth with your neighbor, friend, or family member who is seeking reliable information about a South Carolina personal injury or workers' compensation claim. Dirk J. Derrick of the Derrick Law Firm Injury Lawyers is responsible for the production of this podcast, located at 901 North Main Street, Conway, South Carolina. Derrick Law Firm Injury Lawyers has included the information on this podcast as a service to the general public. Use of this podcast and any related materials does not in any manner constitute an attorney-client relationship between Derrick Law Firm Injury Lawyers and the user. While the information on this podcast is about legal issues, it is not intended as legal advice and should not be used as a substitute for competent legal advice from a licensed professional attorney in your particular state. Anyone seeking specific legal advice or assistance should retain an attorney. Any prior results mentioned do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants in the podcast and are not intended as endorsements of any views or products. This podcast could contain inaccuracies. The information contained in this podcast does not constitute legal advice and is not guaranteed to be correct, complete, or up to date as laws continue to change. In this podcast, you will hear information about focus groups. Please note that not all of the firm's cases are presented to a focus group. Additionally, when speaking about juries or jurors in relation to a focus group, we are speaking of focus group participants and not actual trial juries or jurors.